please follow a few basic hygiene rules. Kindly keep your microphones muted at all the times and post your questions in the chat box. Now, to formally commence today's conference, it is my privilege to invite the founder of Let's Learn Law, Mr. Anand Verma, to share his opening remarks and also introduce our esteemed keynote speaker. Mr. Verma is a seasoned legal professional with around 2 decades of extensive experience, including significant exposure to arbitration and dispute resolution. As a managing partner at his full service law firm Team Legal, he has handled complex commercial matters, bringing a strategic and solution oriented approach to resolving dispute efficiently. His strong grasp of arbitration frameworks and practical insights into dispute management make him exceptionally well suited to today's session. We are delighted to have him leading this engaging conference today. So now to start the conference, I now hand over the session to Mr. Anand Verma, sir. Please, sir, I am requesting you to address the audience.
A very warm welcome to all of you on behalf of Let's Learn Law. Thank you, Ishika, for that warm introduction, and a very warm welcome to all our speakers, participants, and guests joining us today from across India and different parts of the world. It is truly a pleasure to have you all with us. On behalf of Let's Learn Law, both myself and my co-founder, Dibesh Srivastava, extend a very warm welcome to each one of you to today's conference. At Let's Learn Law, one thing we strongly believe in is that the law is constantly evolving. It evolves with business, with society, and today, more than ever, with technology. And that is exactly why conversations like this become so important. When we look at arbitration today, especially in the Indian context, we can clearly see that things are changing, not just on paper, but in practice. With the recent reforms, the push toward institutional arbitration, and the broader vision of improving dispute resolution in India, there is a genuine effort to make the system more efficient, more reliable, and more globally aligned. But what I find even more encouraging is the shift in how people are thinking about arbitration. It is no longer seen as just an alternative to litigation. It is increasingly becoming the first choice, especially in commercial matters. Along with that, we are seeing a growing interest among young lawyers who now view arbitration as a serious and rewarding path. In fact, arbitration today is evolving at a very rapid pace as a specialized and high growth career avenue. Young professionals are no longer limiting themselves to traditional court practice. They are actively exploring roles as arbitration practitioners, tribunal secretaries, research associates, and working with arbitral institutions and international forums. The exposure is not just domestic, but increasingly global, which makes this field both dynamic and highly aspirational. At the same time, it is important to recognize that every reform, no matter how progressive, brings its own set of challenges, whether it is adapting to institutional frameworks, addressing concerns around cost and accessibility, or ensuring fairness and due process in a digital environment. There are practical issues that need to be acknowledged and addressed. And that is precisely what we aim to do through this conference. While we celebrate the progress that has been made, we also want to have an honest and meaningful discussion around the challenges that remain, and more importantly, explore practical solutions that can strengthen India's arbitration ecosystem going forward. For us at Let's Learn Law, this is exactly where we want to contribute. Our aim has always been to bridge the gap between what is taught and what is practiced, between experienced professionals and young learners, and between global developments and the Indian legal ecosystem. This conference is a small step in that direction. It is not just about discussing reforms or institutions, but about understanding how these changes actually impact practice and how each one of us, especially the younger generation, can be a part of this evolving space. We are truly fortunate to have with us today some incredibly experienced and respected voices from the field of arbitration and dispute resolution. I'm sure the discussions ahead will be insightful, practical, and thought-provoking for all of us. And with that, it is my privilege to introduce our keynote speaker for the evening. We are honored to have with us Justice Rajeev Tandon, former judge of the High Court of Uttarakhand. Tandon is widely respected for his contributions to constitutional, civil, and commercial jurisprudence. During his tenure on the bench, he has played an important role in shaping progressive legal thought and upholding the rule of law. His experience and insightful in arbitration and alternative dispute resolution bring immense value to today's discussion. Your Lordship, it is a privilege for us to have you here. I now request you to kindly deliver the keynote address.
Thank you very much, Mr. Anandji. You have elaborated a lot, and I think all of you are developing the arbitration field much than us, because you are the key for the arbitration matters. The students who are with you are also taking complete training. But I want to say that for the students also, and for the teachers also, for everyone, that what is the emphasis and what is the history of the arbitration, which I will demonstrate before you in order to understand the complete arbitration working. What was the working earlier? What was the working now? And how it is being dealt with. In a short, I will tell you before you. Let us see the preamble of the Act, which provides an act to consolidate and amend the law relating to domestic arbitration, international commercial arbitration, and enforcement of foreign arbitral awards, in also define the law relating to conciliation and for matters connected therewith or incidental thereto. This was the preamble of the Act. And if I come to the this was the just a short preamble, but the real preamble says, whereas the United Nations Commission on International Trade Law has adopted the unilateral model law on International Commercial Arbitration Act, whereas the General Assembly of the United Nations has recommended that all countries give due consideration to the said model laws in view of the desirability of uniformity of the laws of arbitration procedure and the specific needs of international commercial arbitration law. This was the crux of the preamble, that earlier in 1946, we have only domestic arbitration law, and that was too rigid also. One takes the award, then it has to be confirmed by the civil court, and those procedure was there. Later on, this 1940s, after this 1946, the 1996 Act has come up, and now 1996 has also introduced that the international commercial arbitration and procedure for execution of the foreign awards also, all these things have been introduced. There has been numerous judgments on these points, but I will concentrate only the judgment mentioned in the Konark railway station, that is Konkan railway station, where the complete law of arbitration has been defined. Therefore, I will request all the students have this judgment of Konkan railway station, railway corps, and that will describe the whole history of the arbitration, because everyone knows that arbitrator has to be appointed. Everyone knows that two types of arbitration is there: institutional arbitration and ad hoc arbitration. It has to be dealt with under the Arbitration Act. But in order to come to the point of the institutional arbitration or ad hoc arbitration, one has to see the history of the arbitration, how it has been introduced. In Konkan Railways Corps, the Supreme Court had said, at the outset, it must be borne in mind that prior to the 1996 Act, the Arbitration Act of 1940, which was in force in India, provided for domestic arbitration, and no provision was there to deal with the foreign awards. So far as the foreign awards are concerned, the same were being dealt with by the Arbitration Protocol and Convention Act 1937 and the Foreign Awards Recognition and Enforcement Act 1961. The increasing growth of global trade and the delay in disposal of cases in courts under the normal system in several countries made it imperative to have the perception of an alternative dispute resolution system. Now that more particularly in the matter of commercial disputes, when the entire world was moving in favor of a speedy resolution of commercial disputes, the United Nations Commission on International Trade Law, way back in 1985, adopted the United Model Law of International Commercial Arbitration, and since then, number of countries have given recognition for that model in their respective legislative system with the said unilateral model law in view of the present Arbitration and Conciliation Act 1996 has been enacted in India, replacing the Indian Arbitration Act 1940, which was the principal legislation on arbitration in the country that had been enacted during the British rule of the arbitration in 1996. 1996 provides not only for domestic arbitration, but aspects in sweep to international commercial arbitration too. Indian law relating to the enforcement of foreign arbitration awards provides for greater autonomy in the arbitral process and limits judicial intervention to a narrower international mercantile community. Now, therefore, the history of this, that prior to 1940 Act, there were various laws like Foreign Awards Recognition of Enforcement, 1937, 1961, and all that. 1996 Act has come up, which has accumulated all this. It is known as alternative dispute resolution. Now, the very purpose of this Arbitration Act is students, you will find it under Section 7 of the Arbitration Act, which is the main crux of the matter, because which I find that the authors and of this institution have also put an emphasis on the digital working of the arbitration also. If we look to Section 7 of the Arbitration Agreement that defines arbitration agreement, Section 7, in this part, arbitration agreement means an agreement by the parties to submit an arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship. An arbitration agreement may be in the form of an arbitration clause in a contract or in a form of a separate agreement. An arbitration agreement shall be in writing. An arbitration agreement is in writing if it is contained in a document signed by the parties. Exchange of letters, telex, telegrams are means of telecommunication including the communication through electronic in means. Means a message given for entering into the arbitration is also recognized by electronic means. It is called a digital recognition of section 7 in the agreement itself. Suppose an agreement has been mentioned and that is also in writing, maybe, but section 7 provides that exchange of letters, telex, telegrams and other means of telecommunication, including communication through electronic means, which provide a record of agreement. This is called agreement to enter into the arbitration alternative dispute resolution. Therefore, section 7 mandates an agreement. Now, the agreement can be either in writing or it may be in a form of telecommunication electronic form. This electronic form has also been borrowed from Information Technology Act, where section 4 provides that any digital communication is binding, any telecommunication is binding, any communication by electronic media is binding. That has been borrowed from the Information Technology Act. Later on, this Information Technology Act has been borrowed by various acts, that is, under the Arbitration Act, under section 58 of the Saksh Adhiniyam, where Saksh Adhiniyam has provided that any communication by electronic device, that will be called digital evidence, that will be a prima facie evidence, that will be a prime mover evidence. It is called primary evidence, primary evidence. Therefore, section 7, read with section 8 of the Arbitration Act, that is power to refer disputes of arbitration where arbitration agreement, a judicial authority before which an action is brought in a matter which is a subject of an arbitration agreement, shall, if a party to arbitration agreement or any person claiming through under him applies not later than date of submitting his first statement on the substance of the dispute, then notwithstanding any judgment, decree or order, Supreme Court or a court, refer the parties to arbitration. Therefore, after this agreement, either electronic communication, digital communication, written agreement, or letters, the matter shall be referred by the court under section 8 of the Arbitration and Conciliation. Now the question arises how the matter is referred. That is under section 11 of the Arbitration and Conciliation Act. There are two types, that is institutional arbitration is under section 11, which is the sole authority vests with the Honorable High Court, Honorable Supreme Court, and also the institutions like ICI or other institutions which also work on the arbitration law. They also refer the matter to the arbitrator. Now, there are three types of arbitration, two types of arbitration. Number one, sole arbitrator. Number two is the tribunal that makes the tribunal. One person appoints one person as arbitrator, the other person appoints another person as arbitrator. There are two arbitrators, and both join the presiding arbitrator, who is called a third arbitrator, and therefore the tribunal works like arbitrator. All these things are there. The arbitrator has also to give the unconditional his declaration that he is bound by the principles of the Arbitration Act, and he is not he is not known to anyone under Section 12 of the Arbitration Act that he knows the party or anyone. He has to give declaration. Only then he proceeds for arbitration. These are the facts of the Arbitration Act. And now, therefore, after the award is made, the appeal lies under Section 34 of the Arbitration and Conciliation Act, which is confined only to a question that is relates to the jurisdiction, because if some agreement provides that there should be no penalty of interest, there will be no interest chargeable, and the arbiter makes a default of putting an arbitration in the arbitration, the interest also, that will be a jurisdictional issue, and that under Section 34 of the Arbitration Act, that can be interfered. Now, various judgments of the Supreme Court have also come up where it says that the institutional arbitrations cannot be done by the authorities, just like railway authorities. Now, the railway authorities, that is Parikshan case, it has been held that the railway authorities cannot appoint his own arbitrator, his own man arbitrator, and he has to give three names, and amongst the three names, the court has power to choose one of the names, and therefore these things made it very carefully that the arbitrator is bound by the act. Arbitrator cannot give any benefit to any other person, any particular person to whom he is known. All these things are there, and in my submission that the arbitration provides that it has to be completed within a period of one year. Apart from that, within 6 months, the complete pleadings have to be made. And after that pleadings are made, then within 1 year, the arbitration award has to be made. And we have to declare that we are bound to follow up the procedure of giving the award within 1 year, and also they complete the pleadings within 6 months. It is a different matter that under Section 29 of the Arbitration Act, the court has power to extend that period of 1 year in order to see that the evidence was going on, cross-examination was going on. Therefore, one has to accommodate, the court accommodates the arbitrator for giving extension of the period under Section 29 of the Arbitration and Conciliation Act. All these things are there. These are the basic elements. Now, after this basic elements, there are various judgments of the Supreme Court which have to be dealt with. In another seminar, when I am called, I will discuss on each and every issue, just like Vidyavati judgment has come up, which I have argued before the Supreme Court. All these judgments have come up, which I will demonstrate when the occasion arises. Today it is the elementary only of the Arbitration Act, and let the students or the other speakers may demonstrate in other aspects of the matter. And I take leave. Thank you very much.
Thank you so much, Your Lordship, Justice Rajeev Tandon, for that insightful and thought-provoking keynote address. Your words have not only set the tone for today's conference, but have given us a deeper understanding of how arbitration is evolving in today's dynamic legal landscape. The judgment highlighted by Your Lordship have certainly been very carefully by your noted carefully by our participants, and I am confident that they will carry these learnings forward and apply them meaningfully as they progress in their legal careers. Your pointers on Section 34, along with your uh, emphasis on the essential characteristics of arbitration, have truly added depth and, if I may say, brought a certain soul to this entire discussion. Your reflections on the intersection of law, technology, and dispute resolution were both enlightening and inspiring for all of us. We are especially grateful for the clarity and perspective you brought to the challenges and opportunities within the arbitration ecosystem. Your experience and wisdom continue to guide and inspire both practitioners and young professionals alike. On behalf of Let's Learn Law, I would like to express our sincere gratitude for your time and for sharing your valuable insights with us today. It has been an absolute honor to have you with us. Thank you once again, Your Lordship, for joining us and making this session so meaningful. Thank you.
Thank you so much, sir. Thank you. So, ladies and gentlemen, we will now move forward to our first panel discussion on India's path to becoming a global arbitration hub, where our esteemed panelists will deliberate on the role of institutions, reforms, and judicial leadership. We have an exceptional lineup of speakers today, and I am confident that the discussions will be engaging, insightful, and thought provoking. And guiding today's panel discussion is our moderator, Mr. Anand Verma, founder of Let's Learn Law, whose presence and expertise in dispute resolution ensure that this discussion will be both engaging and insightful. Sir, over to you to start the panel discussion.
Thank you, Ishika, once again. Dear friends, over the last few years, India's arbitration landscape has undergone a significant shift. What was once seen as a system struggling with delays and excessive court intervention is now steadily moving forward, becoming more structured, time-bound, and institutional-driven. Much of this transformation has been driven by a combination of legislative reforms, progressive judicial interpretation, and the growing emphasis on institutional arbitration. Through bodies like the International Arbitration Center, together these developments are creating a more predictable and reliable dispute resolution environment, which is essential for both domestic businesses and international investors. We are also witnessing a gradual but important cultural shift within the legal ecosystem itself. There is increasing acceptance of arbitration as a specialized practice and a growing willingness among practitioners and parties to move away from purely ad hoc mechanisms toward more structured, institutional-led processes. This shift is critical if India aims to match global standards and compete with established arbitration hubs. At the same time, the role of the judiciary has been particularly crucial. The consistent move toward minimal intervention and respect for arbitral autonomy is helping build confidence in India as a viable arbitration seat. Recent judicial trends have reinforced the idea that courts are there to support the process, not to re-examine it, which is a fundamental requirement for any mature arbitration regime. Another important dimension to this evolution is the integration of technology and procedural efficiency. With increasing acceptance of virtual hearings, digital filings, and emergency arbitration mechanisms, the system is becoming more responsive to the needs of modern, fast-paced commercial disputes, especially in cross-border matters. However, while the direction is clearly positive, the journey is still evolving. Questions around enforcement, timelines, cost efficiency, and global competitiveness continue to be actively debated within the legal community. There are also practical challenges in ensuring consistency across jurisdictions, improving infrastructure, and building greater trust among international parties. And that is exactly what we hope to explore through this panel, not just where India stands today, but what more needs to be done to truly position India as a preferred global arbitration hub. With that, let me now invite our esteemed panelists to share their perspectives. Let me introduce the esteemed panelist of today's session, Dr. Aman Mohit Hingorani. He is senior advocate at the Supreme Court of India and a distinguished expert in arbitration and dispute resolution. With extensive experience arguing before the Supreme Court, including constitutional benches and various high courts, he has contributed significantly to the evolution of law in India. He is also a trend mediator with the Supreme Court and Delhi High Court mediation centers, an international arbitrator associated with leading global institutions, an accomplished academic, author, and trainer. Dr. Hengorani has also taught at prestigious institutions in India and abroad, shaping the next generation of legal professionals. Our next panelist is Mr. Ashok Kumar Singh, a distinguished senior advocate and arbitrator with over 45 years of extensive legal experience. Based in New Delhi, he has been consistently practicing before the Supreme Court of India, various high courts, district courts, and tribunals, handling both national and international matters, including complex arbitrations impaneled with more than 20 national and international organizations. Mr. Singh has served approximately 50 cases as a sole arbitrator and tribunal member. His vast experience and practical insights make him a highly respected figure in the field of arbitration and dispute resolution. Moving to our next panelist, we have Mr. Sanjeev Nirvani, head of Nirvani Associates, over 3 decades of experience as counsel, arbitrator, mediator, adjudicator, and consultant in commercial laws, including co-arbitrator with Supreme Court and High Court retired judges, expertise in ADR, consumer laws, and business recoveries in diverse sectors. Also a trained and certified mediator, he has attended ICCA 2018 in Sydney and numerous other significant international and domestic seminars, conferences, workshops, etc., organized by SISC, ICC, LCIA, HKIAC, IIM, ICA, etc., actively judging moods like WIS, JESUP, FDI, IMIM, mediation, negotiations, client counseling, and many more. Our next and last panelist is Dr. Jai Prakash Gupta, an experienced advocate, arbitrator, and former assistant professor with a distinguished career spanning over 45 years. He has been actively practicing before the Supreme Court of India, bringing deep expertise across diverse areas of law. Dr. Gupta is a panel arbitrator with the Indian Council of Arbitration and the Bar Association of India, contributing significantly to the field of dispute resolution. An accomplished academic and author, he has also been associated with Ranchi University, shaping legal education and practice. A warm welcome to all the panelists, and let me without delay request you to please give your opening remarks. I would request first Mr. Ashok Kumar Singh for his opening remarks. Over to you, Ashok sir.
You're muted. Thank you. Sorry, what I could understand from your topic today, there are 2 topics which are coming out to my mind, on which we can discuss and which can be of great help to the viewers. Number 1 is that why India is not becoming the hub for international arbitrations, why the international arbitrations are not coming to India. This is something we should discuss, and we should try to find out the reasoning and also the solutions. And secondly, why, despite there are so many arbitration in this country, 85% arbitration are still ad hoc. They are not institutional. I feel this is the easiest way to arrive at at the spirit of the topic which you have given to us. And as far as the international arbitrations, India is not becoming hub. What I am understanding is that we have done a lot of work in this field. We have changed the laws. We have made and enacted new provisions. We have made new institutions. We are working very well. Irrespective of that, the clients are not coming. There are certain reasonings which will be discussed at length. And the few of the reasonings which are coming to my mind is that a lack of confidence in Indian judicial system somehow by the international clients. Functioning of arbitral institutions in India is not, as in view of the international clients, as good as that of international arbitration centers. Conduct of the arbitral tribunal is also very important, which is taken into consideration by them. Conduct of the lawyers is also a factor which is affecting to the international clients. And no definite fee schedule for the arbitrators and the lawyers Internationally, probably we are the costliest. We have the costliest arbitrators and the costliest lawyers in the world. Nowhere so much fee is charged as is charged over here. There are a few factors which affect the international flow to this country, international arbitration matters to this country. As far as the ad hoc arbitration is concerned, that why the ad hoc so much ad hoc arbitrations, what I understood is that probably by making a very good building and by making, a good paraphernalia, it does not mean that we are going to attract the customers to our place. What is more required is that the customer should have the confidence in the system. They should have the confidence in the institution itself. A country where 75% or 70% people are illegally not educated, for them the word institution itself is it creates something in their mind, as if a fear in their mind that we are going to institution, then administrative fees, then people coming over there and going over there, and then initially the name of the arbitrators were, with all due respect to everyone, all honorable judges, 95% or 90 to 95% of them, the honorable judges, the ordinary Indian who is virtually used to have the arbitration while sitting in a room in a very friendly atmosphere, he doesn't find that much confidence. And the cost also creates a little impact upon him. That's why I'm feeling that ad hoc arbitrations are prevailing more. But we will discuss it at length when the discussion would go on. It would be appropriate if you ask some other person if he has got some other views about it, then we will discuss about it at length afterwards.
Okay, Ashok sir, thanks for your insights. I would like to now invite Sanjeev sir to put his views. Sir, over to you.
I would fully agree with Mr. Ashok Kumar Singh on all the aspects he has raised. While we in India have a very good number of advantages, like we are ideally located on the globe in between the West and the East. We have a very good infrastructure. We do not have extreme weathers, but for a couple of months in June maybe. Then we have reasonably priced accommodation and transport as compared to other international hubs of arbitration. And we have excellent intellectual manpower, reasonably priced secretarial services. Yet we are not able to make a good international arbitration hub for most of the reasons already taken up by Mr. Ashok Kumar Singh. But I would like to add that even in ad hoc arbitrations, especially those initiated by financial institutions and other institutions who have a good number of arbitration cases, who they would generally have stock arbitrators who are unilaterally appointed. Despite we having a judgment in Perkins case, still those appointments are happening, and most of those arbitrators are inexperienced. They don't know much about arbitration. That is what is bringing a bad name to arbitration within India, even in the domestic section. So internationally, we need to work on these issues if we want to make India an international arbitration hub. That is it, Anand.
Thank you, Sanjeev sir, for your valuable inputs. And now I would like to invite Jayaprakash Gupta sir for his views on the today's topic. Sir, over to you.
So you're muted.
Sir, you are on mute. Kindly, Gupta sir, you are on mute. Kindly unmute. And
There is some problem appears to be there in his computer.
sir, still you are on mute. Gupta sir, just unmute yourself and then.
Now, am I audible?
Yes, sir. Now you're audible. Please go ahead.
So, as Justice Tandon has stated, what is his remarks, and Mr. Singh and Mr. Nirvani, what we have experienced, arbitration has a root in India since very historically, and as we say that it is the basic dispute resolution system, not ADR, alternative dispute resolution system. What happened if we go from a starting of the legislation of 1937 enforcement of foreign awards and New Convention and Geneva Conventions, and thereafter 1940 Act. And Ancestral has laid down the rules. And we have adopted it and made this act in 1996 and enforced it. There are so many problems till date because we are actually very much not adhered to the spirit of the act. And this is the main problem. And what happened? This what happened? This arbitration in India became very much a good earning, you can say, sector. It should be stopped. Who are involved? And arbitration matter, we should still to be prepared with the international norms for international commercial arbitration. We are not totally equipped or ready for it. What the institutions are doing, what is their moral, and what is the Supreme Court is doing in the arbitration matters. In nutshell and short, I will say arbitration should be treated as a professional work, and arbitrators should be professionals, which they not only time pass or part-time job. This is the main problem within us. And in the institutions also, I have felt that there is a routine work of, you may say, just to please someone. To please someone, they are doing work. And appointment of arbitrators, you will find what happens. They, under Section 11, or the nominated arbitrator, they then come. And what happens in arbitration? The dominating party over the dispute they want to litigate it, delay and everything. And I have noted that in every case, average, there are 30 to 40 sittings in arbitration institutions. When in the ad hoc, it does not take some time, so much times, dates. So these are the things when you want to be arbitration hub, make arbitration hub India, we should behave or we should think on this line. Only that it will be done. Thank you.
Thank you, Gupta sir, for your views. And now I will invite Dr. Aman sir for sharing his views on today's topic. Aman sir, over to you.
Thank you so much, Mr. Verma, and congratulations to Let's Learn Law for this initiative. It is a timely subject because I do feel that, of course, there's a drive to make India in conformity with international standards, both in terms of in setting up centers, infrastructure, and the legislative framework. And I would tend to agree with the previous speakers. But I feel that our landscape in India, which we're talking about, has improved over the last decade. I'm not, completely pessimistic about it. We have made huge progress. At least there's a drive from ad hoc. Of course, as pointed out, majority of the arbitration still remains ad hoc, but at least there's a drive of trying to standardize arbitral procedures, the rules, bring more transparency, move towards institutional arbitration. The kind of infrastructure and the facilities which we have today were simply not there 10, 15 years ago. So we are able to provide that facilities. The courts have time and again reiterated the principle which is central to the central model, that is there should be minimal judicial intervention. Though I am a bit cautious, I would add a note of caution here. Section 5 simply says that the intervention should be as per what's provided in the Act, and Section 34 provides those grounds. So I'm not completely sold with the idea, and I'll explain why, that the courts must have a hands-off approach to cases which do fit under Section 37 or 34. If the Act itself provides, Act doesn't say the court should have minimal intervention. They simply say it should be as per what's provided in this part. And that part would include Section 34. So if the grounds are made out, and the reason for that, given the kind of issues we have in this country, with the kind of advocacy we have, the kind of quality of justicing we have, the kind of quality of arbitrators we have, and the kind of obvious mistakes that are committed in arbitral awards, Section 30, if you can fit your case under Section 34, then why not? So that I'm a bit cautious on that principle, that the court should simply have a hands-off approach. And though the courts have generally reiterated that from time to time, I'll come back to this point in a bit. From the point of view of the government and Parliament, there have been legislative changes, 2015, 2019, 2021 amendments to bring timely conclusion of the proceedings, trying to get good arbitrators, maintain the neutrality, making enforcement better, and so on and so forth. But think about it. We had a 2019 amendment thinking of setting up an Arbitration Council of India. It was only last month in February this year that a 7-member council is proposed to be created. And this is this council which is supposed to grade arbitral institutions, recognize professional bodies for giving accreditation, promoting arbitration training, etc. So you have a 2019 amendment, but it is now that they're trying to enforce it, proposing to enforce it. So that is where that action is required. Similarly, when we have the 2019 the Indian International Arbitration Centers Act, creating the Indian International Arbitration Center, promoting institutionalized arbitration, taking away or taking all the sets of the International Center for ADR, invest it in the government and then onto the center. But the rules, the regulations for conducting arbitration came only in 2023. And it is only in financial year 2024, 2025 that when PSUs like GAIL, ONGC, GAIL, Bharat Petroleum adopted IIAC as designated arbitral institution. So this is a 2019 Act. And it's in 2023, you have the regulations. So we need to put our own house in order. Again, when we're talking about the to amend the Arbitration Conciliation Act to propose bring about appellate arbitral tribunals under 34A, the idea is to set up a two-tier mechanism. Parties can consent instead of going to court, go to the this appellate tribunal, which have the power to set aside the award, partially remand the award, and of course, they're subject to Section 37 appeal, right of appeal would be there. Again, it's still in the pipeline. Nothing seems to have happened. This is 2024. Maybe I may stand corrected, but it will, the comments invited by the end of 2024 is still to see the light of the day. So when we talk that we do have legislative changes, they are not in tune or quick enough. Everything seems to be bogged down. But having said that, you have a desire from the formal legal system to let there be finality of the arbitral awards. Let this be an alternative to the formal legal system, along with mediation, of course. If you see AFCON judgment, we are promoting arbitration, we are promoting mediation, but still not attracting international clientele, which is the theme of today's discussion. For me, I think that in addition to the reasons already given, according to me, our approach has to be first to put our domestic arbitration in order. If you see, if you just look back to other mechanisms where India has stood out, for example, Indian public interest litigation, the human rights jurisprudence, our courts delivered such excellent judgments that you have other jurisdictions citing Indian judgments. So you're building confidence in the Indian legal system. If you have a robust domestic arbitral regime which works, you will automatically attract international clientele. The focus has to be on the domestic arbitral system. And the reason why the domestic system is not working, you can have as many buildings as you want, or the infrastructure, the judgments. If what you do require is good lawyering by the arbitration lawyers, you do require good arbitrator who has even the skills to draft an arbitral award. You find that lacking. If you go back to the basics, arbitration is only a proceeding, it's a process. The skills which we require, the capacity building which we require for lawyers to become arbitration lawyers, or for arbitrators to act as arbitrators, that capacity building, which is still, we still have that problem with the formal legal system. We know the quality of advocacy that is out here. We produce law graduates, we don't produce lawyers. So if you want to have good arbitration lawyers, if you want to have good arbitrators, first we need to have proper training. The lawyers must know how to draft the statement of claim, how to have proper responses. They must know how to do witness handling, how to do cross-examination. We need to go to the basic civil litigation skills which are missing in arbitration lawyers. The arbitrator must know case management. Arbitrator must be trained in that. The arbitrator must be trained in being able to draft a writer's arbitral award containing all the requirements of a judgment. It's going to be executable as though it's a decree passed by civil court. So it can't be open-ended. You can't have clerical errors or computation errors. So there are a whole of other issues, but I would say, yes, we put a domestic arbitral regime in order, and we are able to be proud of that regime, and that regime actually works. We are not going to become an international hub for arbitration. I'm sorry, that's a reality. So I think I'll stop here since I'm conscious of the time, and of course we can have a broader discussion on all this.
Thank you, Aman sir. You have precisely pointed out the strength and weaknesses of the arbitration system. And your one line summed up that we produce law graduates, we are not producing the lawyers. So this line will be very much, we need to put focus on that. If we want to become a good arbitrator, then we need to understand the bits and pieces and all the nitty-gritties of our arbitration system. Sir, I would like to, Ashok sir, I would like to put a question to you that judicial intervention has historically been seen as both a strength and weaknesses. How can India strike the right balance between court support and minimal interference?
Let us understand under what circumstances the party come to the arbitration. Initially, I have been practicing in arbitration for the last about 40 years, so I know initially parties have great enthusiasm to go to arbitration. In 1940 Act, judicial interference was there, but somehow the people are more interested in coming to arbitration. Now the new act has come. Section 34 has reduced the intervention into the award passed by the arbitrators. A very little scope is given in Section 34. We have introduced Section 37 also for appeal. And the scope of appeal is also very, very limited. So normally once an award is passed, the chances of getting it set aside or remanded back to the arbitrator to look into it again is on the very, very lower side. It has positive aspect and negative aspect both. What is positive aspect? The persons who are getting the award, they are very happy. They're going to get the money. In Section 36, the money would be immediately recovered. It is just like a degree. Normally, in cases, the courts are giving the direction to deposit the money in the court or to give the bank guarantee. But kindly see the negative aspect also. Mr. Hingorani says that, do we have that much, experienced and intelligent arbitrators who go to the root of the problem and find it out and give a right award? Number one. Number two, is it not a fact that sometimes the integrity of the arbitrators is also at stake? Number three, what is the reason, which I understood when I was talking to some government officers, that why the government has passed a notification that if the dispute would be above 10 crore rupees, then there will be no arbitration. Why the government is withdrawing itself from the arbitration when the government wants that India should be arbitration hub? What is the reason behind it? So one of the aspects which has come to the notice and which is observed time and again is that satisfaction of the party before the arbitrator is must. The parties before the arbitrator should consider that they are sitting before a family member, senior family member, who is hearing both of them, giving them the opportunity of hearing within the scope which is given in arbitration. If it is so, the parties are satisfied the interference would be required minimum. The party would not like to oppose the award is passed. Even against the party concerned, I know one of my clients also, when the award was passed, they said it is reasonable enough and we will honor the award. When the party is dissatisfied, when the party considers that I was not permitted to argue the matter properly, or whatever I placed before the arbitrator that has not been considered, or my arguments have not been taken in right perspective, or the judgments have not been looked into, or material aspects have not been looked into. But in Section 34, when we go over there and where the judge says that, look, it is all within the purview of the arbitrator, whatever is decided by him, we are not going to interfere in it, then the party gets disheartened. That is something very, very difficult which we are finding nowadays. with all respect to the honorable judges in High Court, we should have what I understand, that if we want to create confidence and we want that this interference should not be taken as an interference by the parties concerned, we should have the arbitration courts. The judges who are well experienced, who work in arbitration only, just like the arbitration courts in London and the arbitration courts in Singapore, only working in arbitrations, they will understand the problems, they will find, and in case they should not, in any case, even if arbitrators are very highly placed people, even if a former Chief Justice, they should not hesitate in case they find it is the award is liable to be set aside. They must set it aside. Only then confidence will be there. And then Section 34 would not be taken as an interference by those persons who lose the award, the arbitration award. They will not take that Section 34 has not given them any relief, or Section 37 has not given any relief. They would be satisfied. Once this confidence would come, then this legal procedure would be welcomed by everyone, whether person losing the award or whether person is winning the case. So my humble request would be to the government not to make some amendment in the Act to constitute the arbitration courts specifically of those persons who are very well trained in arbitrations. And secondly, those persons who should understand the problems, the genuine problems of the parties, if the party is coming with objections, the genuine problems, give them an opportunity of hearing. And then the moment the confidence is built up, then it will never be taken as interference, or it will not be taken as that courts are either creating interference or the courts are suppressing the process of arbitration. It will not be taken.
Very well explained, Ashok sir. Thank you for giving such a detailed answer to the question. My next question is to Sanjeev sir. Sir, one of the concerns often raised is the issue of inexperienced arbitrators. How does this impact the credibility of arbitration in India, and what can be done to address it?
Yes, inexperienced arbitrators is a big problem. So we do not have any proper certificate course or training course. We do have so many workshops, but no proper training is, no proper certification is there. So the best thing which could be done is when the courts are dealing with Section 34 on awards where it is apparent to the court that the arbitrator was inexperienced or not up to the mark, the courts should pass maybe strictures against the arbitrator and maybe put a impediment on the person being further arbitrator in any other cases. But certification, I must say, is the need of the hour for getting experienced arbitrators or trained arbitrators.
Thank you, Sanjeev sir. Gupta sir, my question will be next to you. Ad hoc arbitration is still widely used in India. What are its key drawbacks, and why should parties consider shifting towards institutional arbitration? And what exactly happens in institutional arbitration that makes it more efficient and reliable compared to ad hoc proceedings? So please, over to you. You are on mute. Kindly unmute, sir.
Okay. Brother, as it is my experience, because we are attached here with the state level, Federation of Jharkhand Chamber of Commerce and Industries, and this textile association, grain association, they have many disputes. They never go to court, and they use the ad hoc arbitration if there is any dispute. And honestly, they adhere to the award. or the mediation or the conciliation. But it is my experience in district, because the institutional arbitration are the matters of big cities, only metros. It is not surprising in a state level. I have seen in Bengal, the old association, traders association, industries associations are there. And they are doing it. And very honestly, there is no problem. In Bengal Jute Association or Textile Association based in Calcutta, I have been there, and I was doing some arbitration cases. Not as an arbiter, but as a lawyer. And I have found they are fair enough. Instead of the arbitration centers in Delhi or Bombay. So what does this? India is a very big country. And we should compare these things with the global institutional centers, arbitration centers, like Singapore or Beijing or London. And we should see, we should review ourselves, and we should evaluate ourselves where we are. If we are interested in arbitration, in institutional arbitration, how it will be. You see, just in 2020, 2023, the India International Arbitration Center is legislated act. Yeah? And it is the provisions are inserted in arbitration and cases. And what will be if the government establish an institute center? What is the motto? How it will work? They have made regulations, more than half dozen regulations. Or what? For to please the bureaucrats or some whom they want to please. These are the matter of discussion. I will request Mr. Singh and Narwali, and that you should think upon them. It should be debated. These problems should be debated. If you want to make really India as an international commercial hub, arbitration hub, we should think upon these things. Why we are lagging behind. But this is my personal experience. And here we are happy with arbitration. No problem. The judicial arbitration. Prior to enactment of these arbitration acts, they were practicing with this arbitration. पंचायती होता था और उसी पर काम चलता था. आज भी कर under the act. And people do not go to courts under section 34. They respect what? In this business state or institute or industries, this character should be taken. They should think who money is being going out, draining out. Just it is the game of big industries. They have not any big worry about the money. AI. That's all. Thank you.
Thank you, Gupta sir, for explaining so well. And my next question will be to Aman sir. But before that, I would like to announce that participants, uh, we are taking questions one by one. So you can chat box. Please, those who have not put questions yet, can put their questions in chat box. And we are having very experienced panelists. So please take advantage of this. And sir, Aman sir, global institutions like SIAC, CIA, ITEC are highly preferred. What are they doing right that Indian arbitration institutions need to learn from? And how do you assess the current state of Indian arbitration institutions? Are they equipped to compete globally, or is there still a long way to go? So over to you.
You see, I would avoid making a sweeping statement because I think everybody would have a different experience about different kind of arbitration centers, and India is a varied country. In India, we do have issues which already been pointed out: monopoly of judicial officers, or you have integrity issues, etc. So there's a huge amount of things that can be done. But you see, and of course, they're all kind of matters. Some may be low value matters, procedural matters. Some are very high stake matters, etc. But to my mind, there has been many people who say, well, people won't mind paying for a costly arbitration if they get a proper result, proper product. That is a proper adjudication of the claim, award which is not likely to be challenged. So if you go to the Singapore Center or to London, etc., and the people have the confidence that, well, we will be paying high fees, etc., it will be a costly affair, but we will get an award which will be final end of litigation. In India, the feeling is even if we go for an arbitral institution and we go and we pay, and as mentioned, we charge a lot, it's costliest out here. Even then, that award may not be up to the mark, and routinely every award is challenged under Section 34. So it becomes only a feeder into a category. It's not an alternative. It's just an additional layer. You go invariably every award is challenged. Our system guarantees that it's not decided expeditiously. Our system is, it takes generations for a case to be decided. So once it gets into that system, and dates are there of 3 months, 4 months, 6 months, and then Section 37, and you go up to SLP 136. So it has become just mixed up with the other kind of cases. So even if you're paying, you're not getting a quality product. So unless we get we are able to offer a quality product to domestic arbitration or international arbitration, we will not be able to compete with arbitral centers anywhere in the world. And for that quality product, the system is only as good as the people who man it. The men and women who man our systems, it depends on their capability, their capacity, their character. It depends on that whether we're able to give a quality product. And that's the reason it was pointed out we don't have training. The Arbitration Council, like I pointed out, is being set up now. 2019 was the amendment. In February 2026, they're thinking of setting up a body to talk about training arbitrators, giving accreditation. So in the Mediation Act 2023, 2026, 34775, we still don't have the Mediation Council of India to give accreditation to mediators. So bad practices are happening in private chambers because it's a confidential process. So what we have, there's a huge area where we need to put a house in order. If you're asking why are people going there, what are they doing differently? They're being professional. They're giving professional service. They're giving value for money. We are not. And that's the reason why arbitration has, I don't know whether institutional court in next mediation has taken off in the country, private mediation has not taken off. Court next arbitration centers like the DIAC, etc., they'll have volume of work. Other institutions may not have that kind of volume of work. So it's a courts still enjoy a lot of legitimacy and credibility in the country. One of the institutions that work in this country, either when we compare with Parliament or the executive, the court people still have more faith in courts than they have in other organs of the state. So if a court-annexed system might still give some kind of confidence, but we need to have the confidence, as was rightly pointed out, for people to say, very well, let us not get into the formal legal system. Commercial matters, Act or whatever it is, let's just try to get into arbitration. Or even under Section 89, parties can agree for the judge and say that we don't have arbitral clause, but let's get into arbitration. That confidence in that mechanism has to be there, which is simply not there in the country.
Thank you, Mansur. Our next question is from Vivu. He is asking, so it is open to all the panelists. With the rise of digital arbitration, how do institutions ensure compliance with principle of natural justice, especially the right to fair hearing?
Could you please repeat it? We couldn't get it.
Yes, sir. With the rise of digital arbitration, how do institutions ensure compliance with principle of natural justice, especially the right to fair hearing?
The rules of the institutions are virtually reviewed time and time to ensure that the natural justice should virtually be there while doing the arbitration. The principle of natural justice is the basis of arbitration. Every institution rule, if you read it, is based upon the principle of natural justice. If there is no natural justice, there cannot be any arbitration. And virtually what Mr. Aman says, he is right. If the properly natural justice principles are applied in arbitration, nobody would like to go in court of law. Everybody would like to get the matter sorted out, except a few who are litigants or old litigants. So only principle of natural justice, as far as the institutions are concerned, their all rules and regulations are based on principle of natural justice, whether they're international arbitration or whether they're Indian domestic arbitration centers.
Thank you, sir. Our next question is from Junaid. He is asking what skills a young lawyer and a student should develop to build a career in arbitration, is both in domestic and international space. Sanju, sir, you could answer this.
Yes.
Okay, to make a career, I must say a young lawyer must join a law office doing a lot of arbitration, attend arbitration hearings, learn from his senior partners or partners appearing in the arbitration proceedings, and maybe attend the conferences by good institutions. That would be enough to learn. But hands-on experience is a must, and attending arbitration hearings to learn is a must for beginning a good career.
I'll just add to that, if I may.
Please.
As pointed out, because this will actually, what sir is saying is a very good idea. It will give you the insight of this application of the substantive law and the procedural law. But in addition to that, I would strongly recommend you must also learn performance skills. How would you analyze a case? How would you formulate a case strategy? How would that case theory, as we call it, gets reflected in your final argument? So, which is basically communication of your case. Final argument is only communication of your case theory to the arbitrator. So you work backwards. Your final arguments will include your evidence. So your case theory must keep into account what evidence was admitted, was disputed, what evidence to bring in, what's your line of cross, unless it's a pleadings only arbitration. Your evidence can't be beyond the pleadings. So all this, before you get down to drafting your claim or statement of defense, you must have your case theory in mind, which has to be reflected out there. Then how you structure your submissions, how do you stitch together your facts, the case law and the evidence on record, present it in a coherent manner before the arbitral tribunal. All these skills are performance skills, are forensic skills, in addition to your substantive law and procedural law. And this is something which, I mean, I've been teaching since '98 now. I mean, almost for more than about 25, 26 years in different universities. And we have clinical legal education programs where we try to have learning by doing sessions, simulation exercises, where within law schools, you're supposed to learn these skills. And you're supposed to, after learning the skills, go and visit the court or the chambers or the arbitrators' chambers to see those skills in practice and learn by seeing those people perform. So these are performance skills. Unless if you don't have these skills, and these skills can be scientifically acquired, you don't need to be born with them. So if you're able to acquire these skills, it is only then these are skills that are common to advocacy, because in arbitration, apart from the Arbitration Act, Sales of Goods Act, Contract Act, and so on. So if your other skills are the same as your lawyering skills, so you must have good lawyering skills. Arbitration is just one area of practice. The skills remain common regardless of whether it's civil law, criminal law, or arbitration. The skills remain the same. And that is something which you must learn, whether in law school or at least when you get into practice.
Anand, I would like to add something in it.
Sir, please, sir,
It
because
is concerning
many,
junior lawyers, and since I have been teaching in the universities also, so just let me.
sir, because the audience consists of students.
Let's be candid.
Yes, sir.
This learning process, even we say making it is a difficult process. All of us, a junior lawyer, must go through the act very seriously. Each and every provision, seriously, coolly, calmly, you read it, understand it, and in case find difficulty, please go through the commentary. The moment you are well conversant with the law, your 30% problem would be sorted out. Secondly, the junior lawyer must have the patience to hear the client. The moment he gets the client, patiently he should hear the client. He should get the entire facts. He should have the entire file with him. Note down each and everything which the client is informing you. Probably anything which is not important for him may be important for your case. That is very important. And thirdly, before drafting any petition for junior lawyer, go through each and every line of the contract. Go through each and every line of the contract, and you will find every answer of every query which you have in your mind in the contract itself. The problem is nowadays the contracts are 300 pages, 400 pages, sometimes 500 pages, so they avoid it. In one of my arbitrations, I have filed I am conducting 22,000 documents have been filed by one party. So I had to go through each and every document before starting the arguments and keep in my mind which document is relevant for my purpose. And they have got a very good opening. They can join any lawyer who is practicing arbitration, may not be very senior, and man who is hardworking, who knows a little about the law, who knows a little about drafting, let them join it. They have another option also. They can join any arbitrator as a junior counsel or as assisting counsel. They will understand, they will go through the files, they will understand how the arguments are placed, when the arguments are appreciated by the arbitrator, and it is a great training period for them. If they get an opportunity to join any arbitration judge, it will be great for him. The 6 month, 8 month, 9 months, if he seriously applies the time over there, read the file beforehand, understand the arguments next day, judgment which are cited, if he makes a note, after a year, he will have entire, directory in his hand with all the judgments. Rather, he would be in a position to write a book, and he will be perfect as far as the legal propositions are concerned. And how to place the argument in the court, he will also understand very well. So now, a lot of scope for the junior lawyers. Only thing is that they have to give the time, they have to give the attention, they should have the zeal, they should have the enthusiasm. If they don't have, please don't come in arbitration. It is a difficult place. Here, legal values are less, but factual position is very important. You must be master of facts. Legally, you may not be good. The law says very well, the arbitrator, whatever he writes, he may not be legally good, but if it sounds good, it is to be upheld. Legally, may not be very, very good, but if you are master file, they are definitely going to get success. Sorry that I interfered in between. Thank you very much.
No, sir, it's perfectly all right. Our audience are much of a younger lawyers and students, so it will be very much beneficial for them. So before we end this panel, I would like from all these SIM panelists to say the final words on today's panel topic. So I'll start from Gupta, sir. So please.
Say only one thing, what Mr. Ashok Kumar Singh has said. Any lawyer or arbitrator who is in arbitration profession, he should seriously go through the act. And seriously, because in my view, the act is in itself is a code. CPC. Like CPC. Nothing is left there. And when the pleadings are good, there are materials in support of your pleadings, then it will survive. And for main thing, for be a good arbitrator or arbitration lawyer, you should work hard. And it should be in a time-bound manner. Time-bound. We have to finish it within the time given. And one thing only I will say, to make India as a hub of international arbitration centers, the centers, established centers, should honestly think of it, why they are not as per the standard of the international arbitration institution. That's all. Thank you.
Thanks a lot, sir. Thanks a lot. Sanjeev, sir, please, your final words.
I would say
Me or someone else? Sanjeev?
yes, sir.
Yeah, Sanjeev, sir. Yeah.
I would say we are still very far from becoming a global arbitration hub, but given the inputs from this panel, if we are able to make amends in the law and maybe some judicial orders to support these problems, to thrash out these problems, we can do it because we have all other infrastructure but for these small problems which can be taken care of.
Thank you, Sanjeev, sir. Ashok, sir, your final words, please.
We are moving ahead to become a global hub for arbitration, but we require certain changes therein. Time has come when we have to change the tone, tenor, and temperament of the arbitrators. They should be very friendly. They should treat the parties as well as the councils very friendly. Now time has come, then we should also change the law. If we know that the Schedule 8 has been deleted or omitted from the Act, time has come that we should again bring it back. Let, besides judges, lawyers, senior lawyers, chartered accountant, company secretary, experts, advisors, they should also be made as arbitrators. Enough is enough. People are not feeling pain of it. We should have the fee structure for international arbitrations. Because there is no fee structure for the international arbitration, very heavy fees is being charged by the arbitrators as well as the lawyers. And in London, there accusing was an opponent to me, he was charging £700 only, £7,000 only for 1 hour, while my fees was 3 or 4 times than his fees. So I could understand very well. We should have fee structure. I'm ready to sacrifice that. Everybody should be ready to sacrifice for our nation, for our country. It is a question of our country. As far as the arbitration center is concerned, we don't have any arbitration center which has a presence all over the country. So a party who is coming from abroad and is asking me which arbitration center I should go, I say Bombay. He said, what is Bombay? Why not Delhi? Don't you have any Indian arbitration center which has a presence all over the country? Which has the sub-centers in Bombay, Bangalore, Calcutta, Madras, everywhere we should try to make out. The government should consider about it. Government should also consider to ensure that arbitration centers should be in the hands of the professionals, the advocate, the persons who are practicing arbitration since long. They may be judges, they may not be judges. And appointment should be in the hand of the only arbitral institutions. Let them appoint anyone whosoever it may be. I feel India will become certainly a hub for international arbitration. And as far as the domestic arbitration is concerned, we should have small arbitration centers in our vicinities, in areas where people should not feel afraid of entering. A big building is not required. A small arbitration center, a small people, they can go over there. They are welcomed like the clients, not as if they have got money snatching device. They should not be taken them. I feel in the domestic arbitration would also slowly turn into institutional arbitration.
Thank you, Ashok sir. Thanks for such deep insights, and we would be very much we would appreciate your true facts and true positions you have placed before this panel to us and all the participants. Final words, Aman sir, from you, please, sir.
Well, as I stated earlier, the route for attracting international arbitration is to have a very robust domestic arbitration regime that inspires confidence in the Indian system. And for that, since majority of the participants are lawyers, I would say junior lawyers or students, when we teach, the teaching method is that you absorb about 30% of what you hear, you absorb about 60% of what you see people do, but you absorb 90% when you do it yourself. So it is that kind of, whenever you get an opportunity to join courses, wherever they're learning by doing sessions, where you get hands-on application, whether it's in the chambers, whether it's with arbitrators, whether it's in the universities, whether they are private bodies, other initiatives, grab that opportunity, learn. Arbitration advocacy, like any other advocacy, is a performance skill. You can have as much bookish knowledge as you want. You can have substantive law, procedural law. But if you can't get up and apply to persuade the tribunal to give you relief, or as an arbitrator, you're not able to manage the arbitration proceedings, so you're not able to write an award, then the entire exercise is futile. So it all depends about building your individual capacity, and there's no reason whatsoever the kind of talent we have, the kind of resources, the weather, the location, whatever they mentioned with the other panelists, there's absolutely no reason why we can't become the hub for international arbitration. But we do need the systemic changes before we reach that particular point.
Thanks a lot, Aman sir, Ashok sir, Sanjeev sir, and Gupta sir, for taking your precious time for this panel. And I'm very much sure that all the students and all the young lawyers who have joined this webinar will have a great benefits, because tons and tons of knowledge has been shared by our experienced panelists who were practicing as arbitrators since decades. So now you can take all the skills what are required to enter into an arbitration field, how you can become a good arbitrator, all the shortcomings, all the future preparedness, and what is the current position is now before you. So thank you all from Let's Learn Law. It's our pleasure to have you all. Thank you, sir. Thank you.
Thank you. Thanks a lot. Thanks to everyone. Thanks to everyone.
Thank you so much, sir. Thank you.
Thank you, everyone.
Ladies and gentlemen, we will now move forward to our next session, focusing on from ODR to minimal arbitration, how little procedure is enough, highlighting how technology is revolutionizing the access, speed, and efficiency in dispute resolution across borders. For this, I welcome Mr. Divyesh Srivastav, co-founder of Let's Learn Law, to start this session. Mr. Srivastav is a legal and policy professional with around 10 years of experience in litigation, public policy, and regulatory affairs. He began his career as a litigation lawyer before transitioning into a policy domain, where he worked with leading industry bodies such as FICCI and CII. As a co-founder of Let's Learn Law, he led strategic initiatives, research projects, and collaboration while actively contributing as a trainer and mentor. With his background in regulatory and policy matters, he brings a well-rounded perspective to discussions on arbitration, ODR, and dispute resolution. Sir, over to you.
Thank you, Ishika, for the introduction, and thank you everyone for attending this conference and for contributing towards enriching your thoughts and also asking your queries on the most important aspect of today's times in resolving commercial disputes, that is arbitration. And in this session, we move on to the next step, where we want to discuss about how online dispute resolution is evolving in the digital age. And as you know that across borders, I mean, in the previous session, you already looked at India's journey towards becoming a global arbitration hub. This session, we will try to broaden the lens to a more global perspective, examining how dispute resolution is evolving across jurisdiction in an increasingly digital and interconnected world. Across borders, we are witnessing a fundamental shift. Technology is no longer just supporting dispute resolution, but it is actively redefining how disputes are resolved. ODR, or online dispute resolution, is emerging as a key mechanism that enables faster, more accessible, and cost-efficient outcomes, particularly in cross-border and high-volume disputes. At the same time, this transformation brings with it an important and universal questions. As the systems become more efficient and streamlined, how much procedure is truly necessary to ensure fairness, legitimacy, and enforceability across jurisdiction? And that is exactly where minimal arbitration becomes globally relevant, as it challenges traditional procedural norms and invites us to rethink whether dispute resolution frameworks can be simplified without compromising due process, especially in an era where speed and efficiency are critical to international commerce. For this session, we are honored to have with us Dr. Lutz Nieprath, a highly accomplished international arbitration expert with more than 2.5 decades or 25 years of experience, both as a counsel and arbitrator. His work spans across key regions, including China, Middle East, North Africa, Central Asia, Turkey, and Mexico. So he has that overall global exposure that we have been looking for, and so that's why he's the right person to speak and enlighten us on this very important topic. Having worked with leading global firms such as Freshfields and in-house with Robert Bosch, he brings a unique blend of institutional and corporate expertise. A multilingual professional associated with several prominent arbitral institutions worldwide, Dr. Nieprath brings a truly global perspective to this decision. To set the tone of this discussion, and before we dive into the Q&A session, wherein I do have a lot of questions prepared for you, Dr. Lutz, but I would like to invite you to share your opening remarks on, where you can specifically touch upon this very important topic of from ODR to minimal arbitration, how little procedure is enough. Over to you, Dr. Nieprath.
Can you hear me?
Yes.
Oh, thank you so much for this very kind introduction and for the opportunity to speak in front of your audience. Actually, I mean, the topic here is online arbitration, and what I am suggesting here, what I call minimal arbitration, in my view, just goes one step further even. So let me just give you a first idea of how I came to this topic. I mean, having worked in international arbitration for more than 2 decades now, there was a point, let's say it was about 2 years ago, that I felt that all we are doing, not all, but much of what we are doing in international arbitration is a very extensive kind of procedure. And on the other side, I felt sometimes that my clients, or both parties, were most interested not so much in a lengthy or even very detailed procedure, but what counted more to them was to get rid of a dispute, to no longer look back into the past, but to move on, to look into the future, and to finally continue doing operative business, because that is what business is for: looking into the future and doing, well, deals and profitable work. And arbitration, just especially if it involves procedures which regard evidence and the finding of the truth, looks backwards, and also takes away a lot of time to the leading personnel, which they would, I would say, by all means, prefer to use for ongoing business and for looking into the future rather than backwards. So my idea was, why do we have to offer, as arbitration practitioners and in the, let's say, the arbitration industry, very lengthy proceedings, which, yes, have very honorable goals, one of which is to find out the truth and to reach a decision on the basis of the truth so detected. I had a radical different idea, and that is not spending 1 year or 2 years for a full-fledged truth-finding arbitration, but flipping a coin in 5 seconds. That would end the dispute too, if the parties had, well, beforehand agreed on this procedure. I mean, it's a procedure that comes to an end, that comes to a decision. I mean, if we say that a coin has just 2 sides and therefore could end up only in the decision of yes or no, of 100% or 0, well, we could find some let's say, more sophisticated means and could use a cube or something so that we have 6 opportunities or something. That is not the point. My point is finding a solution for the resolving a dispute that is very, very simple. And then look what else we do have to add in order to make the outcome meaningful for the parties. I looked first into the past, into history, and I had some analysis of, well, some phenomena in ancient China, in the early Islamic law, in the where was I to? Roman law. It were just these 3 examples. I'm sure almost every old culture has, in some way or another, similar procedures. And in order to sum it up, what I found was, in almost all of these cultures, there had been a procedure, a legal procedure, that consisted of 2 elements. One element was a very short, a very quick decision-finding procedure, such as, well, not flipping a coin, but they had something similar. They had a quick decision by someone, by God, by whatever, plus a confirmation of someone who was an accepted authority in that culture. Let's say today it might be a notary public, or, well, in ancient times, it were a priest or a high-ranking authority who had to confirm that the procedure of decision finding had followed all rules that had been agreed on or that had been found necessary by religious circles, by whomever. And I wrote about this a little bit on LinkedIn, so if anyone wants to look more into the details, it is still there. And my next point was then, how can we transfer that into let's say, today's time? And then my first question was, what is important today in order to make a decision meaningful? And I can just tell you, it's the New York Convention. So as to have a decision that can be enforced worldwide. I mean, there's nothing better than the New York Convention in the world of I think, of international dispute resolution, because, well, almost the whole world is member to this international convention. So the question will now be, and that was, let's say, the next step of my thinking, how to get the flipping of the coin enforceable under the New York Convention. Well, it would not as such, but the question would be, what is the absolute minimum, according to the New York Convention, that would render a decision an arbitral award, as it is, well, defined in the New York Convention, with a result of being enforceable worldwide? And this question has two answers. One answer is, let's look into the New York Convention itself. And the second answer is, let's look into what national courts make out of it. Because there's no global interpretation of the New York Convention. I mean, we have quite some let's say, very authoritative commentaries of the New York Convention. Let's just think of Mr. Vandenberg. But it's not guaranteed that the court that will have to enforce a specific award will really only follow one of those commentaries. But in most cases, there are also, let's say, legal cultural ideas behind the reasoning of the judges. So, for example, in Western Europe or in the US, the party agreement will have a very, very strong importance in the reasoning of the judges. This will be different in other cultures, so that we will have to look into, let's say, each culture at least, and the precedents in many countries, and perhaps we can even find clusters for this, in order to know exactly what the minimum procedural elements will be in order to get the flipping of the coin enforceable. Let me just end here. I'm still developing these ideas in well, a series of short articles on LinkedIn. That is just my current, let's say, thinking, which can be observed by everyone who likes to read that. And in the end, I will write, well, a comprehensive article about it for a journal or something. But currently, I'm still on the way, and that is the idea, what I just introduced to you. And I'm really grateful to have the opportunity to introduce these ideas here in this forum, because the online dispute resolution is something that aims, well, that goes in the same direction, but just leaves out one step, which I propose here. Online dispute resolution speeds up things, makes dispute resolution more accessible and more efficient than it has ever been before. My minimal arbitration looks into what is absolutely necessary. Let's just throw overboard everything that is not necessary, no matter how efficient we can do it. So the flipping of the coin, that's the point of departure. Thank you very much.
Thank you so much, and very, very interesting concept with respect to this. And if I'm able to, understand it correctly, if we want to, let's say, move towards minimal arbitration, and you have been talking about the important characteristics of minimal arbitration that form part of the traditional arbitration system as a whole. So have you been able to also pinpoint, let's say if you're not able to say, what could be part of minimal arbitration, have you able to, find out what could not be part of, maybe just exclude? Do you have an exclusive list of these things? Okay, remove these XYZ things from the traditional arbitration ecosystem so that we do serve the same purpose, but more faster than even the traditional arbitration mechanism as well. So can you throw some light on that?
You mean what is absolutely necessary? So
Yeah.
So
what can be like, what will be done away with in the traditional ecosystem to get to this minimal arbitration point?
I would rather look at it from the point of that we look what do we need in addition to the flipping of the coin. Well, we will need something under the New York Convention. We'll need, for example, an arbitral agreement that covers everything that will happen in that procedure. Well, the flipping of the coin, no. The flipping of the coin, of course, is just a metaphor, but a very, very concise and short procedure that leads to a decision. So we need to have all of that described in the arbitration agreement. So it will be a little bit more sophisticated than the standard arbitration agreement, in order to never let's say violate against the agreement. And a next point will be the nomination of the arbitrators. There needs to be an arbitrator. There needs to be a procedure in which they are nominated. This procedure can be very, very short. It can be just one arbitrator, and it can take a very short period of time. It needs just to maintain accessibility for both parties. The next step would then be that there is a procedure according to which both parties are able to present their case. And then there will be, but again, this doesn't mean that there is the opportunity of 2 rounds of submissions. We can have that shorter, much, much, much shorter. Well, for example, shifting as much as possible into an oral hearing. And we can have that oral hearing, once again, thank you for this forum, online, so that things can go much faster than so far. And we will have the arbitrators to think about the facts, to think about what the parties have put before them. This does not mean that the arbitrators have to think about it for days or weeks or months, but they have to think about it. And let me finish at that point. That's more or less the major issues. We will have some more little details, and those details will depend also on the legal culture under which enforcement is being sought. But basically, the major issue is the arbitration agreement, that we have an agreement which describes the procedure exactly the way it is intended to be done, and so that in the end, I mean, I heard that during my my research for my my PhD thesis. I did a lot of interviews with judges in many countries, and what I heard several times there was, well, we don't like the parties going to arbitration and not to us because we are better than the arbitrators. That's the position of the judges I spoke to. But they say if the parties have agreed so, then they have to bear the consequences. And even if the arbitrators are not as good as us as judges, well, they agreed on it, and there they go. And that is the idea I think should be applicable in also with minimal arbitration. You look at the arbitration agreement, and that's what the parties have chosen, so that's what they get. Thank you.
Thank you so much. And I actually wanted to, take this concept on the, kind of disputes that come into arbitration. So when you talk about minimal arbitration, are we thinking of a scenario where all kinds of disputes that generally go into traditional arbitration, many of them are very, very complex commercial disputes as well. So do they all fit in this criteria, or is there, or we should just test it out with some kind of disputes and then we see, okay, this is a success that's coming out, and then maybe, expand it. So what are your thoughts on that?
Yes. Thank you very much for that question. It really comes to the core of minimal arbitration, because I would say, once again, the solution, or let's say the point of departure for my answer is the arbitration agreement. I mean, it is up to the parties to choose minimal arbitration, and wherever they think it is more important to get to a quick resolution, I would say that even very complex situations and very complex disputes are feasible under minimal arbitration. But, and I agree to you, it doesn't look like from first sight, because you just don't let the parties enough time for elaborating on all of their questions. So the issue with very complex disputes will be simplification. The parties will have to simplify because they don't get enough time to go into all details. They will have to focus on what really counts for them, and the arbitrators will have to decide, or the arbitrator will have to decide on that basis. So it will be simplification. There will be details that cannot be taken into account, but it will only be if the parties so wish. And if there are parties that want to go into the details, well, don't go to or don't use minimal arbitration. But I would not say that the complex disputes are not fit for minimal arbitration.
Understood. Understood. So, moving around, in the interest of time, I do want to, look at the future on this, very interesting topic that you've been working on. And in your perspective, how do you see this concept evolving and fitting into the, existing regime, let's say 5 years, 10 years down the line? And considering that, a lot of our audience are, young professionals across the globe, how do you think the jurisprudence around this is going to evolve?
Thank you for that question, because that touches up on, well, the issue of whether it will fly or not, whether it will remain just a theoretical idea of someone who was in a crisis about existing arbitration and who just dreamt of the flipping of a coin. I admit that the ultimate test will be to get a couple of awards really enforced. If all judges that that have to decide in an enforcement procedure decide against enforcing a minimal arbitration award, well, then it remains a theoretical thing. And perhaps we won't find any parties who will include any more minimal arbitration agreements into their contracts. But I am pretty confident that, let's say, after a couple of or a larger number of conferences and discussions like this one, with lots of critical questions, we might be able to improve the idea and the practice of minimal arbitration to an extent that it would also convince real judges. And of course, the idea, in order to really bring it on the ground, and in order for it to be able to show whether it flies or not, there needs to be an arbitral institution that does the marketing, that has the rules, that has and provides the arbitration agreement, and which tries to get it flying. And that will be step number 3 then. I'm still in step number 2. Thank you.
Understood. So yeah, as we could come to the close of this discussion, I do, like you said, the ultimate test, but the validation will come from as an end when we have certain awards, being granted on this particular concept. And so have you, I mean, is there any real life case studies that you have seen, this actually being fruitful for the clients as such, or for the parties in dispute as such?
Let's say I have not yet put it into the field. So minimal arbitration does not exist yet in real life. What gave me quite some hope, no clue whether it will there will be more of these decisions, these enforcement decisions, but I forgot which of the courts in charge in Mexico it was that enforced what was it? A decision basically just made by a blockchain. And well, they had put a real person in between as an arbitrator. But this arbitrator, the only thing he did was to copy and paste the award by the blockchain and signing it. Well, that is not really enough for saying that it was a human mind that had thought it through, unless that arbitrator would testify that he had thought about it and he was completely convinced of what the blockchain had said. But this comes very close. This decision, which allowed for and ordered the enforcement in Mexico, that gave me some hope that that under the New York Convention, at least in Mexico, the human factor can be minimized to just copying and pasting and signing. So that comes, I would say, that exceeds even my my wildest dreams.
And how would you, how would you see how do you see the role of AI in this? Do you think it is going to play a role in this, in bringing this concept into, light, with the, increasing penetration of technologies, trying to minimize the human involvement in such cases to enable faster resolution of disputes? Do you think it will play a role there?
We touch now upon an issue, let's say, for which I am too old, because trusting in a decision and letting a decision rule over our real life. So when it's being enforced, when we allow enforcement, that has not been at least read and reviewed in a certain minimal fashion by a human being. I think that will go against our feeling of well-being. I would not trust this. Perhaps today's young colleagues who grew up with mobile phones, with apps and all that, will not have the slightest problem. I just grew up with paper and pencils, and perhaps, yeah, you could call me a dinosaur, but that makes me frighten a little bit if we give away the decision power completely to a blockchain and an AI or whatever, electronical, without any real human being. Even though I must admit, I also don't trust human beings as such. I mean, you have to be careful with everybody, as it is the truth with AI. But I see that the generation after me might accept it. And I mean, flipping a coin and letting an AI decide, if I'm very honest to myself, there's not that much of a difference.
Yes, on that note, thank you so much. And I am pretty sure that the work you've been doing on this particular concept, we will see some positive developments in the near future, and especially our young colleagues here, they will, along with arbitration, this concept of minimal arbitration, because ultimately we want to get justice, disputes resolved as fast as we can, so that we carry on the businesses without any, as smooth so as best we can. So on that note, thank you so much, Dr. Lutz, for your time. You're all the way signing in from Germany, so thank you so much. And it's a pleasure to have you, and we look forward to having you in our future sessions as well. Thank you so much.
Thank you very much. It was a great pleasure.
Bye.
Thank you, sir. Thank you so much.
Yes,
Should I get out?
Ishika.
Or yeah.
Ishika, you want to?
Yeah, thank you, sir, for your valuable time and to make this discussion like enriching and so insightful. Thank you so much. And dear participants, Kindly note that the feedback form has been shared in the chat box. You will receive your certificate of participation once you have done the successful submission of this feedback form. Make sure that you enter your name in the capital letters with proper spacing, as certificates will be generated automatically and cannot be corrected afterwards. So we kindly request all the participants to follow this format to avoid the errors in their. Before we close this session, I would like to thank everyone again who participated in this conference and for showing such great energy and curiosity. This is just one of the many interactive sessions we host regularly at Let's Learn Law. Thank you again for being part of today's session. We look forward to seeing you at our upcoming events. Have a wonderful evening. Goodbye. Everyone, please fill out this feedback form. The form is working. Everyone is filling it. The form is working. Kindly check your internet connection. It's working. You can try again. Please refresh your page and try filling out this feedback form again.